Okay, we're going to begin with week 8 of your Social Security bankruptcy and what's the other one? Social Security bankruptcy and workers' comp class. Sorry, I'm focused on bankruptcy here. So we are going to be starting on chapter 11. We're going to be talking about how the trustee liquidates assets, distributes money, and the debtor's right to hold on to some property. This is a pretty involved chapter. I encourage you to read this chapter in addition to listening to the lecture. There's quite a lot of information in here. There are a lot of technical terms that go with the bankruptcy code, and so I want to make sure that you understand this is kind of the end of the bankruptcy process before discharge. This would be we're going to be talking about cases that don't involve, that aren't no asset cases, right? The no asset cases are a no-brainer. There's really nothing to distribute, so we're off to the races. But where we have some assets, we have some secured creditors, we have some liens, judicial liens, and just security interests, we need to make sure that, again, the creditors are protected. That is the key that I want you to remember throughout this whole bankruptcy process. This isn't a process that protects debtors. It is a process that balances the need to give a debtor some dignity and the ability to have a fresh start, and balance that against the creditor's need to be repaid, because if creditors think that they're never going to be taken care of when someone files for bankruptcy, credit dries up, the economy slows down, bad situation. Okay, so what happens when a creditor, when a trustee says, okay, I've got this inventory, I've got this stuff in your estate, what am I going to do with it? Well, the first thing that a that a trustee will do is look and see, first of all, what parts of the estate the bankruptcy court is interested in holding on to so it can be liquidated and then money distributed to creditors. And generally, there isn't a whole lot when we're doing a Chapter 7, because where debtors do have assets that are worth money, they don't file for Chapter 7 bankruptcy. They'll file for Chapter 13 and reorganize. So the first thing that the trustee is going to do is say, okay, we've got a lot of stuff, it's not worth a lot, we've got exemptions, what can I hold on to? Those items in the estate that the trustee doesn't want to bother with, we say the trustee abandons. And the way that we know that the trustee has abandoned it, there are several different ways, but the most common is the trustee will look at the debtor's schedules and will say, hey, I don't think that exemption really covers what the value of this property is, and I'm going to go ahead and get an appraisal. I'm going to object as the trustee to the valuation on the exemptions. So if there is no objection filed by the trustee, the property is abandoned. It means the bankruptcy estate has no interest in it. The debtor is going to hold on to it. It's abandoned by the court. Okay? Now, let's say that there's a car and the debtor owes $5,000 on the car. The car is worth $5,000. The property will be abandoned by the court because there's nothing there for the court to sell. Right? The secured creditor has an interest in the property of $5,000. There's an exemption of $1,000 or whatever the state or the federal exemption is. there's no equity there, there's no money there for the court that would justify the court selling the car, because the security interest, the secured creditor, is going to take their money, the debtor is going to take their exemption money, there's nothing for the court. And so it will be abandoned by the court. If there is anything that the court wants an interest in, it will file an objection to the exemption, and it will go through the procedure for selling the property, and we'll get to that in a little bit. Okay. If there is a judicial lien or a lien on the property, the court can still abandon the property because the lien is worth as much as the value of whatever the property is. Okay? So really this is just a way for the court to say, what is there here for us to sell so that we can pay the creditors? Okay? Where the court says, hey, we are going to go ahead and sell a piece of property, there has to be public notice about it. And that public notice has to have a time and place for the public sale, the terms and conditions for the private, if it's a private sale, and the time that's fixed for filing objections. So if the court says, if the trustee says, hey everybody, there is a collection of whatever that we are going to sell, you have to give notice to everybody. Why is that? Well, it could be that someone can come in and actually buy it, and then the money will be paid to those creditors, and the creditors want to know everything about that sale. They have to be given notice. There are situations where you have a business that is being liquidated, and the business is going to continue in some form after that liquidation. There are specific hearings on how that happens, and we're not going to get into that, even though this chapter talks about that. Okay? So let's say that the trustee does hold a public sale, sells some items from the bankruptcy estate. What happens to that money? Well, the trustee is guided by the priority rules within the bankruptcy code of who gets paid what when. And it goes in a specific order. So administrative expenses are going to be paid first. And those are the actual necessary costs and expenses of preserving the estate, including wages, salaries, or commissions for services rendered after the commencement of the case. And they include the trustee's estate, if we hire an auctioneer, those professional fees, or an appraiser, their professional fees, any kinds of taxes that are incurred. So if there's sales tax that's incurred, then the proceeds will go for that. Actual and necessary costs and expenses of preserving the estate, which can include wages, salaries, and commissions incurred after the commencement of the case, and actual and necessary expenses incurred by creditors who file an involuntary petition with the estate. Okay? If we are looking at who gets paid what, on page 358 of your text, there is illustration 11-A. So secured claims get paid first. If a creditor is fully secured, has filed his financing statement and security agreement with the recorder's office, whatever amount is fully secured gets paid to that creditor first. Any partially secured claims, if there's not enough money but there's some money that comes from a sale that money will get paid to that secured creditor. Then there are priority claims. The bankruptcy trustee's fees and expenses, domestic support obligations, other administrative expenses, claims for wages, certain farm equipment. All of these are priority claims. They're not secured, but they're priority. And then comes general, non-priority, unsecured claims, which means deficiency claims where a creditor, let's say, has repossessed a car, and they had to pay for the transportation for the car, they had to pay for the sale of the car, they had costs that were associated after the sale of the car. Maybe when they sold the car, it didn't cover the whole debtor's debt. Those are called deficiency judgments or deficiency claims. So those are just general claims that come next after priority claims. Then claims for fines, penalties, forfeiture, punitive damages, interest at the legal rate on priority and general secured claims. And then if there's any money left over from the sale of that particular item, it goes to the debtor, which generally is nothing. Okay? If a debtor decides, hey, I want to retain property, there are lots of different things that can be done through the court so that the debtor can retain personal property. Okay, the first that we've talked about already is your reaffirmation agreement, where you say to the court, look, I have this MasterCard. I want to reaffirm that debt. I want to sign an agreement with that creditor so that it's like I never filed for bankruptcy with them. Now, the creditor and the debtor can negotiate new terms. New interest rates are very typical, or wiping out old interest charges. And I keep using a car as an example because it's the most common example. If you have a car and you need that car to get to work and you owe a loan on that car, you're probably going to reaffirm that debt. You're probably going to go to the debtor and say, how about if I owe you 2 months, how about if I pay you those 2 months of payments that I missed, you get rid of the interest charge, and we negotiate a lower interest rate. Okay, sometimes that works. Sometimes you just reaffirm it outright. It just kind of depends on the situation. But a reaffirmation agreement is something that you have to tell the court you're going to do. You have to file a notice of intent with the court saying, I intend to reaffirm this particular debt. Why is that? Well, you're telling the court, first of all, that this particular secured item, if it's secured, if it's unsecured, not so much, but especially if it's secured, that the court pretty much is going to be forced to abandon this property. There's no possible way that they're going to be able to include this as part of the estate, and it's not going to be sold. You're also telling other creditors, hey, we know that there's this debt that's listed, but it's being taken off the table because we're doing a reaffirmation agreement. Okay? Everybody's got to sign it. The debtor's got to sign it. It's a new contract. Okay? Another way that a debtor can keep property is by redeeming it. The right of redemption is used where you have a tangible piece of property, it's worth something, and you tell the world, I will pay the fair market value, the liquidation value of whatever this piece of property is. Your book uses the example of, say, a washer and dryer. You know, if you buy a washer and dryer today, it's kind of expensive. And the minute you take it out of Lowe's or Home Depot or wherever you buy it from, it goes down in value. And once you use it, it goes down in value even more. And if you decide they're listed on Craigslist or Facebook Market or whatever, it's kind of even lower. And that's kind of the fair market value standard. What can I reasonably sell these items for in the marketplace? That's a value, and that's the value that most creditors want to hold to. Most debtors will say, well, if you come and pick up this washer and dryer, you're going to sell it basically at liquidation value, not fair market value, which is lower than fair market value. And so what some debtors will do if they want to keep their washer and dryer is say, hey creditor, we'll pay you the liquidation value of this washer and dryer. You're going to have to sell it at auction anyway, where the trustee is going to have it sold at auction anyway. You're going to get 10 cents on the dollar. Let us redeem this piece of property by giving you the 10 cents on the dollar. Lots of times there's fights about the value. There's negotiation about the value. There can be motions filed, and the court can decide what the liquidation value is. But by the time the court decides it, it's not worth anything. So sometimes creditors will say, hey, I'll go ahead and take the redemption value of it. And that is one way that you can, again, avoid doing a reaffirmation agreement where you're saying, I'm going to pay this debt in the future. If you have money available that you can borrow or whatever, that is a really good option for people. And it's usually used for things like appliances, where you've taken there's a secured creditor out there, but they know that they're undersecured because you're paying interest and you're paying on, say, $2,000 for a washer and dryer. That's not the value of these things, and there's an exemption that the debtor's going to be able to take anyway. You're going to lose money on the deal, so you may as well just take some money through the redemption process. Okay? If there is a judicial lien on a piece of property, and again, when I say property, I don't mean like your house. I mean, if there's a lien that's been taken through the court, you haven't paid a bill, somebody's taken you to court, they have a judicial lien against your piece of property, you can try to avoid that lien. You can try and say, hey, my exemption is more than what this lien is in the property. Can we just trade off? It doesn't really happen that way. It sounds really good on paper, but sometimes it's really hard to do. There is a lien stripping option that is also available to the court. What happens is you will look at what the value of whatever the collateral is or whatever the property is that secures the lien, and you will bifurcate the lien. So let's say I have a lien on a car. Okay, there's a lien on my car, but the lien is only worth part of what the value of the vehicle is. We're going to strip away the lien to the exact value of the vehicle, which lowers the amount of the lien. Why do we do that? Again, we're trying to jump through hoops to make sure that there's some money out there to be distributed amongst creditors and to give creditors any kind of collateral that they want to take back. And so stripping out the real value of the property from the lien itself at least guarantees that the lien holder is going to get some value for the lien. Okay? I know that that's complicated. I know that there's a lot in there. Just understand that if a debtor wants to keep property, there are tools available to the debtor in the bankruptcy code. The most common are redemption and reaffirmation. Those are our most common tools that a debtor will use so that they can keep property. Redemption requires some finagling, some negotiation, and the debtor's ability to come up with money, which is kind of tough to do sometimes. And reaffirmation is the debtor saying, I'm gonna commit myself to a future debt. Lots of times lawyers will try to talk their clients out of these reaffirmations because there's a reality check here. If you're filing for bankruptcy because you lost your job, why are you going to commit to a future debt? If you're filing for bankruptcy because you lost your job and you took a lower paying job, or you've gone through a divorce and so you've got all of these debts and you've split in half the income that was being used to pay all of these debts, why are you going to commit to a future debt? Sometimes it's hard to convince clients that that's not a great idea. Now, I think I told you before what my recommendation usually was to take one of the major credit cards, Visa, MasterCard, Discover. Make sure that one of those cards with the lowest balance on it is reaffirmed. And that's strategic. That is so that the debtor, after the bankruptcy is over, has a line of credit. And that line of credit can be used to build credit because your creditor is going to be in the toilet. It's already in the toilet before the bankruptcy, but after the bankruptcy, it's official. Here it's in the toilet. This gives you a line of credit, but I would only make that recommendation for people that didn't file for bankruptcy just because of the major credit card debt. If you've got major credit card debt and you're filing for bankruptcy, really kind of foolish to continue to have future debt because you've already proven that you can't control how you use credit. But it is a strategic kind of thing that most bankruptcy lawyers will recommend to their clients. Look, we want to make sure that coming out of this you've got some kind of stream of credit and that you can use it judiciously. Redemption is really smart if you can negotiate a low liquidated value for whatever it is you want to redeem, and if you have a flow of cash that you're able to do that. Lots of people, once they file for bankruptcy and they haven't had to make their payments for a few months, have some cash that they can use for redemption. And so that is a plus for filing for bankruptcy, is you can actually breathe. So you have some money so that you can redeem or catch up old payments for things that you want to reaffirm. Okay? Lien stripping is something that the lawyer and the trustee are going to look at together and figure out how we are going to adjust these liens. And that is more for the creditor to be able to take some kind of value and then collect on it. But that is something that, hopefully you don't have a client that has gotten in a position that they're filing for bankruptcy because they're trying to avoid a garnishment or a collection on the lien. Okay? There are some real life examples in your text, and just because in this class we have to do this plus Social Security and bankruptcy, I don't get into the weeds too much with that, but I do recommend that you read this chapter. There are lots of good examples in this chapter that give you some dollars and cents to work with, so it makes a little bit more sense. Okay? All right, we're going to end here. Check for your discussion, check for your vocabulary and your assignment for this chapter. We're in the home stretch. We've got 2 more weeks we're going to be learning about closing out a chapter 7 and getting into a chapter 13, just an introduction for chapter 13, and then you're going to have your final. So for week 11, you will not have a lecture and you will simply have a final exam that you have to do. Okay? again, any questions, any concerns, please reach out to me. Happy to go over anything with you. If you want to go over some of the real life examples in the text, I'm happy to do that. I don't do that in this lecture because I don't want to get you confused, because we are just kind of skimming through how to do a chapter 7. Okay? But any questions, please feel free to reach out to me.